welcome to the greatest show of all time.
Defense calls here for Patterson.
Thank you. We'll have her brought in.
Since I'm being rushed to judgment. Just 1 second, I'm trying to find some. One second, I'm trying to find this.
Did you print that for me for some emails?
Some reason, odd reason. Good morning, Miss Patterson.
Good morning.
So, what do you do for a living?
I have my CNA certificate.
I'm going to direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question.
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think
Miss
that kind
Corey.
of got a little ahead of...
Oh. Mr. Brooks, I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead. Ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection. And grounds for... I object to that and grounds for the objection on behalf of the state.
Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
The
what the-
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking my card beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interaction, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant. He was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you seek
Do
to
you
have
want to
contact?
open up the door to the other act's evidence of
That's
you?
not opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a misstatement
no,
of the
that is
evidence.
true.
No.
She said it herself.
No, marking an exhibit is not creating an
No,
exhibit.
not marking an exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going
it's
to give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right?
fair.
Witness.
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
I
the
want
letter?
to see
Y'all
the
want the
letter.
email? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so
know
I gotta
when you
bring that in.
received it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
don't want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a
It
ruling.
threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask
servant,
a
Your
question.
Honor. I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Stated so yourself on record that your job is being the umpire.
Apologies.
My apologies, too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And
state-
what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make a
be
record
found.
of a variety of
So who
things.
took my paper?
And you keep interrupting. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. You interrupt. You attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
Was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption
made-
that I'm saying?
Can I please make the record without you
Yes,
interrupting?
you may. Yes, you may. I apologize.
I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question.
Did I say anyone touched my table? I didn't say
You implied it, sir.
But did I say that? I never
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it,
All
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table. Or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. Many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
Because it has no validity.
When did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't... I referred to this one because this one had the pictures. But
And why do you
the
believe
one,
it was from
to
Ms.
answer your question,
Patterson?
to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need
knows
the
that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think
no,
she's
still
ever
nothing.
said she was
Oh,
afraid. I think that was the officers who may have stated that. But how does it
Your
relate
Honor.
to her credibility before the
Who
jury?
else could it be? Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean sign? No
How
one
do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding?
letter? No, I'm not kidding you. I need
I'm
to.
gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail.
Is there some information in them that only she would know? Did she sign the letters?
I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming.
Like how else am I supposed to answer that? So it has to be put in a legal
The
term
bottom
or
line is
something?
I need the letter. So the bottom line is I'm not going to allow any questioning without having that letter. I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes,
Everybody
yes, we can
assumes-
hear it very
And
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic. where you
Because
try to
it's
go
not a tactic,
off
it's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
it's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objection to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the.
These pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So
That
I'm not
because that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that.
Brooks.
No, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was. when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
no,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the
All right,
record.
under Illinois, unless he brings that letter and
Don't
he can
sit
show
here and try
it
to
is
think you know what's
inadmissible,
going
she will
on.
not be questioned, and under 90611, I will
You
declare the
gonna talk about
cross-examination
You don't know where,
closed.
You don't know where, what
Thank
happened
you,
at
we're
the
in
time
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. one witness left?
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Who's supposed to come at 10:30, Your Honor?
Call your next witness, please.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
And who determined this order? That's not the witness that was intended to be called at this time.
I understand that, sir, and I don't.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time. The witness.
Which is respected, but at the same time, being that this is my time
Right, I'm
to
going to
present my
excuse the
defense.
jury for right now. I'll rise for the jury, please. Cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no, you
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
Of witnesses.
Why is it always so hard to just say yes or no?
Yes,
is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it, that's
you told
fine.
me
You
your
want to
authority.
object and note it, that's
told
fine.
me your
Your
authority.
objection
I'm
is
not
noted
debating
on the record.
your authority. I'm not. That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with the
You
last?
said you wanted to raise
said-
an issue with about Detective
What I
Guzman's
said was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
He's been released.
If I mumble something under my breath, somehow that's audible. But when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. If you choose to call Ms. Patterson, this is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that
And
from the
so
beginning.
then I asked
Your
you
Honor,
to put
with
him
all
in
respect,
blocks.
did I not inform Your Honor and the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You
I
may
did.
disagree with
It's
it.
not
You
about
have
that.
been-
It's about the rush
you
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed.
I never
and
asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
If
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
Because
normal
if you-
in a trial
You can't
to call
put the people.
witnesses
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for
availability.
me, Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here.
With all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with. We're going to call this witness at this time.
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So
a
here's the
with a shock
situation. It
device
is
on my ankles.
9:52.
So how's I'm trying to control anything? I just want this to be fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair
Explain to
because
me how that's
the
fair.
process that has been set up to frankly help you.
No, this it's not helping me by it's helping the state
And no.
by being able to say if we know the time and we know
You
the
did
person
not.
and we
I
know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave
yesterday-
them my witness list. It's
Yesterday,
not my fault.
I very
It's not my fault. They
expressly-
weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the deal.
to do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm gonna stand my
It
ground
is-
too, but I'm
if
not
you
gonna I'm not
don't
gonna
call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
when the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law-
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You
witness
have to
this,
cooperate with this process.
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have been
now.
called at this time, Your Honor.
It is
It's not no game. That's
It
what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what
Let me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
It is
some crazy
unfair.
shit
It's
that's going on.
unfair. It is disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And I understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
Nah, you're not rushing me to judgment. I don't care what you're talking about. You a public servant. Reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that's
It's obvious. It's clear. The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your
I see through it.
and your
Nice
see
try,
through.
but I see through it.
Has-
No, that's what's being done.
You
Come
could
on, man.
ask these questions. You could
Come on,
ask
man.
these
Got the right one.
witnesses certain questions, and you're not.
far from an idiot.
They're yours.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying this
something
right
and
now.
don't know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm instructing you to
Come on, man.
avoid the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before you do that, there's an issue that.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit
witness
me, so let's
has
be
a
clear about
prior
that.
record.
Y'all fooling. I set the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not.
Has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
I'm coming undone. I'm coming undone too.